Now, we've talked about your independence from a president. There's also the question of independence from the legislative branch, equally as important. You're going to be asked about your personal views on a variety of topics and whether you believe various Supreme Court cases were correctly decided. Presumably, this is because senators are going to try to predict how you'll rule in cases before you. The idea is that if you agree with your personal views on, if they agree with your personal views on particular issues of morality or on Supreme Court precedent, they maybe would vote to confirm you. If not, they might not. Of course, that's improper. Judges should never promise their future votes on the bench in exchange for a senator's vote for them. If you answer these questions about your views on specific Supreme Court cases or public controversies of the day, you'd be showing the opposite of independence from the legislative branch. Politicians can make promises about how they'll vote on issues. Judges, by the very nature of the job, should never promise any outcome. If a nominee answers these questions, it threatens to undermine judicial independence. Of course, there may be times where it's appropriate to reconsider certain decisions, especially if more recent opinions have called into question the rationale of the original decisions. So, with this in mind, I'd like to explore the approach that you'd take towards Supreme Court precedent. Could you tell us your views on the value of precedent? I think you've already done that. But if you want to expand on it, go ahead. Have you ever followed precedent of the Supreme Court when doing so conflicted with your personal beliefs?
Well, my personal beliefs are not relevant to how I decide cases. The role of precedent in our system, which I said is rooted in Article 3 of the Constitution, it's not just a judicial policy. The role of precedent is to ensure stability in the law, which is critically important. It's also to ensure predictability of the law. People who order their affairs around judicial decisions need to know that the law is predictable. Whether you're an individual or a business or a worker, you need to have predictability. People rely on the decisions of the courts, and so reliance interests are critically important to consider as a matter of precedent. They are one of the reasons we have the system of precedent, so that people can rely on the decisions. Precedent also reinforces the impartiality and independence of the judiciary. The people need to know in this country that the judges are independent and that we're not making decisions based on policy views. Part of that is to understand we're following a system of precedent of what has been done before. The court, every time someone gets on, it's not just bouncing around to what do I think's best. It's what's the precedent of the Supreme Court is always part of the analysis, an important part. And for 12 years, I've been applying precedent of the Supreme Court and of my court. Every day for 12 years, I haven't been getting up saying, how can I rewrite the law? I've been getting up for 12 years every day saying, okay, how can I apply this Fourth Amendment precedent to this fact pattern that comes before me? Or how can I apply this First Amendment precedent to this fact pattern that comes before me? So precedent is the foundation of our system. It's part of the stability. It's ensuring predictability. And it's just foundational to the Constitution, as Article 3 and Federalist 78 make clear.
Now you'll be asked by other members which Supreme Court precedents you like and don't like, but as you know, it's